Hi. Today, since I have like 5 subscribers now, or is it 6? No, it's only 5. I'm doing another video, and today it's in black and white because I felt like being in black and white today. The subject of my video today is marriage. This is a thing that I did. We had a program at my church a couple of weeks ago talking about marriage, and talked about same-sex marriage and traditional marriage, or what people like to call traditional marriage. We had a presentation on the history of marriage and things like that. The history of marriage is not the way a lot of people think it is. But anyway, my part was about some of the legal arguments for allowing same-sex marriage. And I wrote this little bit, and then I read part of the dissenting opinion of Justice John Marshall Harlan from the case of Plessy versus Ferguson. And I explain what all this is in the part that I wrote here, so I'm going to read this. In 2003, the Massachusetts Supreme Judicial Court, in the case of Goodridge versus the Department of Public Health, ruled that under the state constitution, same-sex marriage could not be prohibited. The state legislature was given 180 days to change the marriage law to provide every citizen with the freedom to marry. Marriage activists compared Goodridge versus Department of Public Health to the 1954 Supreme Court ruling in Brown versus the Board of Education, which struck down the doctrine of separate but equal. During the presidential campaign in 2004, I heard President Bush's campaign manager, Ken Mehlman, say that it was wrong to draw that comparison. Instead, Mehlman said, the proper analogy is with Plessy versus Ferguson. The decision in Plessy versus Ferguson, he said, was the result of activist judges misinterpreting the Constitution to suit their own beliefs. Plessy versus Ferguson was a case before the Supreme Court in April 1896. Homer Plessy, a man who was 1/8 African American, was convicted of attempting to sit in a railway coach designated for white people, a crime that carried a fine of $25 or imprisonment in the parish prison for 20 days. Justice Henry Billings Brown, in the majority opinion of the court, upheld Plessy's conviction by Judge John Ferguson. And then I have a little excerpt from the majority opinion, which I really want to read in a southern accent because it makes it sound more racist, but Justice Brown was actually from Massachusetts. Interestingly, Justice Harlan was from Virginia, and his brother-in-law was half black, which might have had something to do with his opinion. But anyway, I'm going to read it in a southern accent anyway. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction upon it. That's fun. Okay. The difference between the case of Plessy versus Ferguson and the Goodridge case in Massachusetts is that the former was meant to uphold bigotry, whilst the latter is meant to grant equality to all people. The lone dissenter in the case of Plessy versus Ferguson, John Harlan, wrote, "The 13th Amendment does not permit the withholding or the deprivation of any right necessarily inhering in freedom. It not only struck down the institution of slavery as previously existing in the United States, but it prevents the imposition of any burdens or disabilities that constitute badges of slavery or servitude. It decreed universal civil freedom in this country. This court has so adjudged. But that amendment Having been found inadequate to the protection of the rights of those who had been in slavery, it was followed by the 14th Amendment, which added greatly to the dignity and glory of American citizenship and to the security of personal liberty by declaring that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside, and that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. These two amendments, if enforced according to their true intent and meaning, will protect the civil rights that pertain to freedom and citizenship. In view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights as guaranteed by the supreme law of the land are involved. It is therefore to be regretted that this high tribunal, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state to regulate the enjoyment by citizens of their civil rights solely upon the basis of race. In my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. It was adjudged by that case that the descendants of Africans who were imported into this country and sold as slaves were not included, nor intended to be included under the word citizens in the Constitution, and could not claim any of the rights and privileges which that instrument provided for and secured to citizens of the United States. The recent amendments of the Constitution, it was supposed, had eradicated these principles from our institutions, but it seems that we have yet, in some of the states, a dominant race, a superior class of citizens which assumes to regulate the enjoyment of civil rights, common to all citizens, upon the basis of race. The present decision, it may well be apprehended, will not only stimulate aggressions more or less brutal and irritating upon the admitted rights of colored citizens, but will encourage the belief that it is possible, by means of state enactments, to defeat the beneficent purposes to which the people of the United States had in view when they adopted the recent amendments of the Constitution, by one of which the blacks of this country were made citizens of the United States, and whose privileges and immunities as citizens the states are forbidden to abridge. We boast of the freedom enjoyed by our people above all other peoples, but it is difficult to reconcile that boast with a state of the law which practically puts the brand of servitude and degradation upon a large class of our fellow citizens, our equals before the law. The thin disguise of equal accommodations for passengers in railway coaches will not mislead anyone, nor atone for the wrong this day done. Now, the ruling of the Massachusetts Supreme Judicial Court not only recognized that it is wrong to deny legal protections and responsibilities inhering in civil marriage to same-sex couples, but also that the separate but equal institution of civil union would put the brand of servitude and degradation on same-sex partners, because the only equal of marriage is marriage. So that was what I read at the church, and everybody seemed to like it. There's one guy named Bob who's a lawyer, and he came over and told me the thing about John Harlan's brother-in-law, which was pretty interesting. And I don't think I have anything else to say. So, goodbye.